India Legal presents Court This Week. Hello and welcome to Courts This Week. I'm Dina Osha. In this special editions of Courts This Week, we bring to you top stories of legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Courts. We bring in selections of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you of all the important proceedings from the week. So let's start Courts This Week. India Legal presents Court This Week. A Supreme Court bench headed by Justice Ashok Bhushan has allowed the National Law School of India to conduct the admission tests NLAT 2020 as per the schedule 12th of September. However, the bench has restrained the administrations from declaring the result and making admissions. The bench was hearing a petition filed by former Vice Chancellor of NLSIU, Professor Dr. R. Venkata Rao, and aggrieved parents of the CLAT aspirant challenging the sudden withdrawal of the NLSIU Bangalore from the CLAT 2020 to hold a separate entrance test, namely the NLAT 2020.
The Supreme Court has allowed National Law School of India University Bangalore to conduct its separate examination, the National Law Aptitude Test, this year. However, the result of the exam will be subject to the court's final decision in the matter. The matter was taken up for hearing by a bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah. NLSIU's move to conduct a separate law entrance exam this year owing to the delayed conduct of the common law admission test came under challenge by one aspirant's parents along with former NLSIU's Vice Chancellor Professor Venkata Rao. Senior advocate Nidhesh Gupta argued that the decision of NLSIU to have a separate entrance exam is violative of the bylaws of the Consortium of National Law Universities. He informed the court that NLSIU was a part of NLU Consortium. After Gupta took the court through the chain of events leading up to NLSIU's September 3rd notification, Justice Bhushan asked, "Main question is, can NLSIU hold a separate entrance, not the mode?" Appearing for Professor Rao, senior advocate Gopal Sankranarayan informed the court that the number of students who registered for NLAT was one-third the number of candidates who signed up for CLAT. At this point, the court expressed its willingness to issue notice in the matter. However, senior advocate Arvind Datta, appearing for NLSIU, pointed out that the exam was scheduled to be held tomorrow. Datta went on to explain the reasoning behind holding a separate entrance test. If admission were not completed by September, then the institute would have lost 16 crore rupees by not admitting the 120 undergraduate students and other postgraduate students. He further assured the court that NLAT was only for this year and the next year NLSIU would go for the CLAT. Senior advocate P.S. Narasimha, appearing for the NLU Consortium, argued all the law university used to hold their own exams. The court considered this issue the consortium was set up. Sankranarayan sought to point out that West Bengal and Bihar are under lockdown tomorrow, the date of the exam. Datta pointed out that the exam was an online one. Amid these protestations, the bench went on to direct respondents to file a counter to the plea within 3 days and listed the matter for 16 September. The petition filed through Advocate Sughosh Subramaniam and Advocate on record Vipin Nair on behalf of Professor Rao and an aggrieved parents claimed that the decision of the Vice Chancellor, Professor Sudhir Krishnaswamy, to conduct a separate test would convert NLSIU from being an island of excellence to an island of exclusion. Bureau Report.
Actor Riya Chakravarti, brother Shauvik and 4 others have been denied a bail after her arrest over the drugs charges linked to the Sushant Singh Rajput case. The bail request of her brother Shauvik Chakravarti and other accused have also been rejected by a court in Mumbai. Riya Chakravarti's earlier bail request was rejected by a magistrate who sent her to jail till September 22nd. A special court in Mumbai has rejected the bail pleas filed by the actress Riya Chakravarti and her brother Shoaik, who were arrested by the Narcotics Control Bureau in connection with the drugs cases linked to the death of the actor Sushant Singh Rajput. On Thursday, the NCB strongly opposed Riya's plea and referred to her allegedly procuring drugs for Rajput through Shoaik and the late actor's two staffer as a drug procurement nexus. The NCB claimed that Riya was having conscious knowledge about the drug consumption by Sushant Singh Rajput and made herself a part of the offence by procuring drugs for him. The agency also referred to a statement which it claimed was given voluntarily by Riya and will be legally admissible in court. Riya, however, in her bail plea said that she has since retracted the statement, claiming that she was coerced into making it. The charge pertaining to financing illicit traffic has the maximum prison terms of 20 years and is non-bailable. In her new request, she had retracted her confession and said that she was coerced into making self-incriminatory confessions. She said her life is at risk in judicial custody, that she had received rape and death threats, and that 3 investigations had taken a several toll on her mental health and well-being. Riya Chakravarti's petitions for bail said that she had not committed any crime whatsoever and had been falsely implicated in the case. But the Narcotics Control Bureau argued that she had conscious knowledge of drugs used by her boyfriend Sushant Singh Rajput and made herself part of his offence by procuring drugs. The NCB, while opposing the bail plea, also said that Riya had used her credit card and payment gateways to facilitate the financial transactions related to dealing of the illicit drugs trafficking, which was revealed through a call data records, WhatsApp chats and voluntary statements of co-accused. The agency further opposed her bail plea, stating that if released, she may tamper with witnesses. The agency also told the session court that if released on bail, the actor may tamper with the evidence and also try to win over the witnesses using her positions in the society and money power. Bureau Report. The Supreme Court has refused to entertain a fresh plea filed seeking postponement of NEET, a UG examination by National Testing Agency in wake of the COVID-19 pandemic. The pleas also sought reliefs like having more number of NEET exam centers and holding the eligibility tests of the NEET in more than one shifts. The bench observed that old arrangements will be made for the NEET exams and there cannot be different dates for different states. Also, no matter what date is fixed, there will be some difficulty. A 3-judge bench of the Supreme Court has dismissed fresh pleas urging the court to reconsider the conduct of the medical entrance exam NEET on September 13, 2020, in view of the rising cases of the COVID-19 and constraints faced by students amid lockdown restrictions. The lead case of the Keshav Maheshwari was moved through Advocate Alak Lok Srivastava. 2 other pleas by the Arijit Sao and Pragya Pranjal have been filed through Advocate Anubha Srivastava Sahai. The pleas were dismissed by a bench of Justices Ashok Bhushan, Subhash Reddy and M.R. Shah. Senior advocates Arvind Dattar and KTS Tulsi and advocates Shoaib Alam and Neela Gokhale also appeared today on behalf of the petitioners. Concerns were raised today over the lesser number of test centers in certain states. Senior advocates Dattar pointed out that Bihar only had 2 centers. The court, however, responded that there cannot be different dates for different states. Whereas Dattar urged for the exam to be postponed by 3 weeks, the court remarked that a review plea in the matter also have been dismissed. Senior advocate Tulsi pointed out that the country is at a stage where 90,000 cases of COVID-19 are being reported daily. He also urged the top court to consider the Bombay High Court recent directions to ensure that students who are unable to appear for an entrance exam on account of the pandemic be appropriately considered. The court said that these are matters for the testing agency to examine and not for the court to pass directions on. Advocate Alam argued that the guidelines and SOPs issued for the conduct of the exam have certain lacunae. The court, however, observed that the concerned authorities will take all necessary precautions for the safety of the students. Alam urged the court for directing the local authorities to ensure that the guidelines are enforced. All this will be done, the court responded. Alam, however, pressed further for directions from the court on their specs, pointing out that a slight nudge from your lordship will go a long way at a time when there is a cap on large gatherings and there is 100 of students who have to go out to take the exams. Whereas Advocate Gokhale had also sought to make submissions on the matter, the court cut short her arguments and intimated that it is not inclined to entertain the pleas. The petitions were thereafter dismissed. Bureau Report. A three-judge bench of the Supreme Court has stayed the operations of the Socially and Educationally Backward Classes Act 2018, which granted Maratha quota, and has referred the issue to a constitution bench of 5 judges or more for a final adjudication. The bench, comprising of Justices L. Nageshwara Rao, Hemant Gupta and S. Ravindra Bhatt, further held that no appointments or admission shall be made under the impugned Act for the year 2020-21. However, the postgraduate admissions that have taken place till date shall remain unaltered. The Supreme Court referred to a larger bench a batch of petitions challenging the Maharashtra State Reservation for Socially and Educationally Backward Classes Act, which provides for reservation in employment and education to the Maratha community. The bench of Justices L. Nageshwara Rao, Hemant Gupta and S. Ravindra Bhatt has held that in the meanwhile, there will be no such reservation in jobs and admissions. The court had further ruled that admissions to postgraduate courses will not be altered. The matter will now be placed for Chief Justice of India, S.A. Bobde, who will constitute a larger bench. The bench had heard the parties on the questions of reference of the matter to an 11-judge constitution bench on the issue of 50% cap on reservation. Senior advocates Mukul Rohatgi, representing the state of Maharashtra, the senior advocate Kapil Sibal, representing an applicant, urged the court to refer the issue of the 50% ceiling on the reservations to a larger bench. The SCBC Act provides for reservation for the Maratha community in the state for Maharashtra. The decision of the Bombay High Court upholding the law with modifications was challenged before the Supreme Court. One of the primary grounds for challenge was that this law, if implemented, would breach the 50% upper ceiling in place for reservations. With the change in the demographics of society, there is a need for the upper ceiling to be revised. The senior counsels in support of the SCBC Act had argued. It was further argued that this case needed to be examined by a bench of 11 judges, considering that the judgment delivered in the Indra Soni case was delivered by a 9-judge bench. Counsel in favor of making the reference to a constitution bench had argued that after the 103rd Amendment providing for the EWS reservations, the ceiling fixed at 50% was breached in almost all states. It was pointed out to the court that in the Janhit Abhiyan case, the challenge to the constitutional amendment providing the EWS reservations has been referred to a constitution bench. Therefore, a statutory enactment like the SCBC Act should also be similarly referred. On the other hand, senior counsel like Arvind Dattar and Gopal Shankar Narayanan, who opposed the reference, argue that if the court decides on the SLP filed and concludes that the Maratha community is not socially and educationally backward and as such not eligible for the reservation in the first place, the questions of breaching 50% is rendered void and the matter may not be needed to be referred at all. It was argued by these lawyers that the matter be heard on merits, and if during the hearing the court is of the opinion that a reference is needed, the same can be done at that later stage. Bureau Report. The Maharashtra police has filed an affidavit in Supreme Court with details of the punishment meted out to the 18 police personnel for their role in being unable to prevent the lynching of the 2 sadhus in Balgar. Earlier this year, it is informed that the Department of Inquiry was ordered against the police officers who were prima facie found to be negligent and in the derelictions of the duty with regards to the handling of the situations and preventing the commissions of the crime. The state police further appraised the court that after the departmental inquiry was conducted, show cause notices were issued on July 27 to 6 police personnel having considered their replies. A final order punishing 18 officials was issued on August 21. In light of the action taken, the state police has urged the court that there is no further need for an investigation to be carried out by the CBI or any other court-monitored investigation in the matter. Further opposing the pleas before the Supreme Court, which calls for a probe by a central agency, the state has sought dismissal along with the impositions of the cost on the petition. The Delhi High Court has directed Delhi University to issue digital degree certificates for students within a maximum period of 1 week after completing the verifications. A single judge bench of Justice Pratibha M. Singh, while hearing the matter through video conferencing, noted it is accordingly directed that DU shall henceforth not insist on physical submissions of the documents for the purpose of the issuance of the digital degree certificates. The bench has further directed Dr. Sanjeev Singh, the director of the Delhi University Computer Center, to consider creating an urgency tab on the portal itself so that students who have an urgency can submit such additional documents on the portal, rather than sending a separate email to establish urgency. The bench was hearing a bunch of petitions seeking directions with regards to the issuance of a degree certificate to the pass-out students urgently, as the students require the documents to take admissions for further studies in foreign universities or jobs. The council appearing for the DigiLocker informed the court that the students who have graduated in 2017 can obtain their certificates from DigiLocker further. As per the rules 9A of the IT, preservations and retentions of information by the intermediaries providing digital locker facilities Rule 2016, the certificate generated from the DigiLocker system is equivalent to the original degree documents. The bench also directed DU officials to file an affidavit capturing the details, and a proper timeline shall be given as when the degree certificates shall be issued for both urgent and non-urgent requests. The matter is further listed on September 11th. The Supreme Court has asked the Government of India and the Reserve Bank of India to take concrete decisions on the issues of the sector-wise loan restructuring within 2 weeks. A 3-judge bench of Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah took up the case for hearing. The court was told by the Solicitor General Tushar Mehta that various aspects of the issues were being considered by the Union Finance Ministry and the RBI in consultations with the banks. However, a period of 2 weeks more was required for the affidavit to be filed. The court asked the centre to come up with concrete decisions on the issues. Senior counsel Kapil Sibhal, appearing for the real estate associations, highlighted before the court that despite the court's interim order, there was credit downgrading taking place. On the other hand, senior advocate Rajiv Datta pointed out that a concrete declarations on the specific issues of interest on interest has to be made. Datta said that while the decisions of the loan restructuring was a welcome one, it should have been done earlier. Datta, who was representing the petitioners in the case, also said that the individual borrowers continue to suffer. It was contended by senior advocate Ariyama Sondaram that with the moratorium period ending on August 31, banks have begun debiting interest amounts. It was urged before the court that borrowers need to be protected from the coercive action. In a hearing in contempt case, the Supreme Court has framed larger questions. Also, the Apex Court has impleaded Attorney General K.K. Venugopal in the case. Decisions on the amicus curiae to be taken soon.
The Supreme Court has directed that the case record in the 2009 contempt case against Advocate Prashant Bhushan be sent to Attorney General K.K. Venugopal. The case was taken up by a bench of justices A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna. Senior advocate Rajiv Dhawan, appearing for Bhushan, informed the court that Attorney General K.K. Venugopal had stated during an earlier hearing that he would like to assist the court and thus should be impleaded as an amicus curiae. The court said that Venugopal would be impleaded in the case as per Rule 10 of the Supreme Court rules. A decision on whether he would be appointed as an amicus curiae in the case will be taken later. Dhawan also submitted that there are more questions of law to be framed in the case, as the court had earlier stated that it would add to the list of 10 questions submitted by Bhushan. The matter will now taken up during the week commencing from 12th October. The matter was initially placed before a bench headed by Justice Arun Mishra, keeping a view the larger question that emerged from the case and the lengthy hearing the same would require. Justice Mishra's bench had directed for the case to be placed before another appropriate bench. An order to this effect was passed on 25th August when Justice Mishra was just days away from demitting office as a Supreme Court judge. On 17th August, after hearing the parties at some length, the bench expressed its willingness to put quietus to this case. It also observed that larger questions emerging from the case needed to be addressed and decided. The court had asked the counsel involved in the case to address the following questions. In a case, public statement as to corruption by a particular judges is permissible, under what circumstances and on what basis it can be made, and safeguard, if any, to be observed in that regard. What procedure is to be adopted to make complaint in such cases when the allegation is about to conduct of a sitting judge? Whether against retired judge any allegation as to corruption can be made publicly, thereby shaking the confidence of general public in the judiciary, and whether the same would be punishable under the Contempt of Court Act. The instant contempt case dates back to 2009 when Bhushan made statements alleging corruption in the judiciary in an interview. The Supreme Court has subsequently taken suo motu notice of the issue after a complaint to this effect was filed by senior advocate Harish Salve, amicus curiae in the case. The contempt petition was held to be maintainable by 3-judge bench on 10th November 2010. Bureau Report.
The hearing before the Bombay High Court on the PIL's move against the media trial while reporting on the investigations into the death of the actor Sushant Singh Rajput saw a fervent pleas being made for media regulatory bodies to first examine the complaints made over the issue. The central government, through its Ministry of Information and Broadcasting, has also filed an affidavit to this end, which states, with regard to the content violations in the print and electronic media, the petitioners may approach the appropriate forum. This forum takes necessary actions on the representations in accordance with the existing guidelines, rules, regulations. The affidavit details that complaints on the unethical media reporting can be dealt with by the Press Council of India, which is a statutory body governing print media standards, and the Self-Regulatory News Broadcasters Association. The NBA, in return, has set up the News Broadcasting Standards Authority, which deals with the complaints concerning broadcasting TV channels. In their affidavit, the centre has informed that complaints over the reportage in the Sushant Singh Rajput case have already been received and that the same is being inquired into. It is also stated that the advisories have been issued by this regulatory bodies on reporting on suicides and in Sushant Singh Rajput case. Further, it stated that the Ministry of Information and Broadcasting also has an institutional mechanism to deal with the violations of the program codes. Well, that's all in courts this week. Thank you so much for tuning in. Keep watching APN and stay safe. India Legal presents Court This Week.